Don't let your final farewell stir up family feuds. Welcome to Before You Go, a podcast brought to you by Texas Estate, Trust, and Guardianship Attorneys, Stacy Kelly and Keith Morris. Preserve your hard-earned legacy. Be in the know.
Hello, this is Keith Morris and Stacy Kelly. We are here today for Before You Go, things you should know. And our discussion today is going to be about community property law in Texas and the impact that that has on the probate process. We'll talk about a few different things, homestead, and the differentiation between the homestead that a spouse is entitled to and the homestead that you're entitled to according to creditor laws. So we'll go through all that today. It's important to understand community property in Texas because in the event that someone dies without a will, what is community and what is separate comes into play and is very important. And so, Stacy, just tell us, generally speaking, what is community property?
Okay. Texas is one of 9 states that have community property. Community property refers to property that is owned jointly by the spouses during their marriage. It encompasses all property and earnings acquired between the date of marriage and the date of death or divorce, regardless of whose income paid for that property. Also, examples include employment, income from employment, real estate purchased, vehicles acquired. On the other hand, separate property includes assets that were owned before you married, gifts that you received individually, anything you inherit, or personal injury settlements. So that's a basic overview of community versus separate.
And one thing that, you sort of get into murky waters with property acquired prior to marriage and then you maintaining that property during a new marriage. Like, for instance, if you have a business prior to marriage, the business is separate, but the income from that business, at least as far as your employment goes, is community. But then, depending on the circumstances, any payments that you receive that don't count as employment payments may be community and may not, or may be separate, depending on the circumstances, right? I mean, that's one of the issues.
Right, and it's presumed in Texas that it's community property. So someone who wants to argue it's separate property, they have the burden to prove that and have to trace that money back because the overall presumption is it's community property.
And also with real estate that's acquired, you and I get married, I own a house before we get married, but you and I continue to live in the house that I purchased. That property may remain my separate property, but if we're using community property to pay taxes, fix the house, make improvements, that doesn't change the characterization of the asset, but it does mean that you'd be entitled to a reimbursement, correct?
Right. It'll affect the value of how much is the community and how much is the separate, correct?
I think that you and I, over the last 25 years, collectively or each, probably this is one of the most widely misunderstood and frequently litigated issues, either as the primary focus in a litigation matter or as a very sticky subset of what we're fighting about, right? I mean, this seems to be something that causes a lot of problems.
And that's, yes, usually involves a second marriage, or there are children that aren't of that same couple, children of the husband or children of the wife, and one passes and, children want a community, let's say, because they inherit a portion of that, or, spouse wants to say it's all community. There's different reasons why someone would argue separate or community.
Yeah, and so when you're applying that circumstance to heirship in Texas and what heirs are entitled to, if it's community property and all of the children are the children of the marriage, then the deceased spouse's interest passes to his wife, correct?
Correct.
But then it gets sticky when there are children from outside the marriage, in which case the surviving spouse retains their one half of the community, and then the other half, which was the decedent's half of the community, is split amongst their children, whether they are outside the marriage or inside the marriage. So then, you have a circumstance where, stepmom her husband has passed away. They have two children together, but he has a daughter or two from a prior marriage. Then, the stepmom is living in the house because she has the homestead right. She has the right to stay there. She also has the life estate. She has the right to stay there. But then she's co-owning a house with, presumably two children that are aligned with her, then potentially two children that are not aligned with her. And so what sorts of problems do you see? And I know some of these are obvious, but problems do you see with that sort of mixed ownership situation?
Oh, wow. Like you mentioned, we'll get more into the probate homestead right or the life estate that the spouse has. But, challenging that, wanting to keep track of the house. Are you paying all the insurance? Are you paying the taxes? Because they have a remainder interest in this house or this real property. And, they think they own it now, but they really don't. They don't have right to possession now, let's say that. But they want to beat up on the stepmom and are you paying this? Are you paying that? Are you keeping track of, did you put a new roof on? All those things. Because you have this joint ownership in some sense.
I frequently get this incorrect, but I think I have it correct today. There are sort of three obligations that apply when it comes to maintaining your property, which is one is taxes, right? The
Yes.
second would be maintenance, and the third would be insurance. And so the life estate holder is required to pay the taxes and the upkeep and maintenance. But then the remainder beneficiaries are the ones that are obligated to pay the insurance because obviously they are insuring their remainder interest. I think I got that right. Am I correct or did I say it wrong?
Well, that's my understanding. So if we're both wrong, that's a big problem.
So, those are the things that cause issues between the surviving spouse and children not of the marriage. Let's talk a little bit about homestead protections. There's homestead protection and a life estate are not the same thing, right?
Correct.
So, talk a little bit about what the differences are and how that impacts.
When one of the spouses dies, the other spouse has an automatic Texas homestead right. You don't have to apply for it. You don't have to file any application. No paperwork is necessary. You have the Texas homestead right. You're allowed to live in the house for the rest of your life. And the other nice thing is creditors can't, with some exceptions, creditors can't reach that. So even if you're, an insolvent estate, you don't have to sell the house to pay any debts. This Texas homestead, it vests right immediately upon death until it is abandoned.
And so we're actually about to try a case, not we, you and I, but myself and another lawyer from outside the firm are going to try a case over abandonment. There are, a couple different circumstances where someone can abandon their life estate interest, which or their homestead right, which is one, physically move out and go live somewhere else, and that's an obvious one. But also failing to comply with their obligations as far as payment of the taxes and the upkeep of the property, that can also result in abandonment, right?
Yes.
And so there is a differentiation to be made between homestead creditor protection, homestead right as a surviving spouse, and life estate. A life estate is what happens in the circumstance where a husband and wife are married. One of the spouses, let's just say the wife, owned the house prior to marriage. She passes away. She has kids from her prior marriage. The husband has a homestead right to live there, but since it's also her separate property, the husband is granted a life estate to remain in that property, which can also be abandoned, but he gets that life estate. In the event that the the children, who are the remainder, they're the, in that case would be the 2/3 owner with the remainder interest in the life estate. Um, if they wanted to buy him out, a life estate has value, right? I
Yes.
mean, there is a numerical value. And where do you go find the numerical value for a life estate?
I always use IRS charts as far as estimated or calculation of how long a person will live normally. And then you take that percentage and you apply it to the value of the home.
So you use the actuarial tables
Right.
that the IRS has, plus there's a valuation based on that to determine what the value of the life estate is. So the other thing is, we don't want to get people to get confused between with the word homestead. Homestead in a probate estate is different than homestead in a bankruptcy estate or in a creditor situation. So homestead in a probate situation or in a marital situation is you have the right to live there because that's where you're living, period. The homestead protections that you're provided from creditors, like you get to keep your house, you get to have one car per driver, you get to have some certain amount of money in the bank, and sheep and goat and whatever else. All of those things, those are protections that the state of Texas gives you for protection from creditors, which also theoretically might apply to probate estate, but it's not the same thing as your right to live there, right? I mean, those are the same but different.
Right. When a surviving spouse has probate homestead right, creditors normally cannot get to that to satisfy debts of the estate, barring like unpaid taxes of that real property, mechanics or construction liens, and some types of unpaid mortgage debts. But other than that, the surviving spouse's homestead is not subject to these creditor claims, nor is it subject to distribution to other heirs and beneficiaries. Like you mentioned before, as long as they haven't abandoned it, which abandonment is clear and conclusive standard. There has to be an intent not to return to the homestead and not to claim the homestead exemption on such property. So that's the homestead exemption you were talking about that you file with the appraisal district, and that lowers your taxes because it's your homestead.
The important thing to remember here is that all of these issues can be resolved by having a clear estate plan, or also and included in that estate plan, especially if there's significant separate property prior to marriage. I know it's not necessarily a topic that you want to discuss up front, but you can include a prenup in your estate plan. And there's a lot of, it's become more and more popular now, at least as far, I've drafted quite a few more than I used to, pre and post nups, because, second marriages, there are workings, both the husband and the wife work, they've both accumulated 401ks and IRAs and this, that, and the other, that they want to make sure remain separate. And so, whereas before it seemed like it was sort of an insulting, question to ask, now it's becoming a little bit more in vogue to say, okay, well, we're getting married. Everything I had before is mine. Everything you had before is yours. And then moving forward, we'll either choose to commingle and set up, that sets up basically three estates, right? His separate estate, her separate estate, and their community estate. But that seems to be sort of the thing that people are doing more often than they used to now. Is that something, would you agree with that? Or have you seen something different? Or what is your experience recently?
Well, I'm seeing them much more often in decedents' estates now where we have premarital agreement and you have to apply that to the will, to the property, to the inventory, to the distribution. So I think the more you can paper everything concerning your assets, do a will, do designations, the better, so that there's less likelihood of some kind of litigation or animosity between people. If it's more cut and dry, it's a lot easier to, manage the estate.
And a question that gets asked fairly frequently that people don't understand is that even if you are married and you have a community estate, each spouse is free to leave their half of the community to whomever they want to, their kids, their parents, their friend, whatever. And then whether that's been something that has been discussed with your spouse prior to doing that or not, they may have a wake-up call when you die and they find your will and realize that their half of your community estate is going to someone that they did not expect, which is basically anybody else other than their surviving spouse, right? I mean, that can and sometimes does happen.
I mean, I've got a case right now down in Galveston where children from different marriages, they had no children together. The wife leaves her husband a life estate in the will in their property and then says at his death, then her half of the community, because she can only control her half in her will, her half of the community, the rest of the property, half of that property goes to her children. And, that normally would work, but we have the surviving spouse who sold it right after his wife died, even though he did not have authority to do so. So we're suing whoever and title companies and him for breach of fiduciary duty. So yes, that's a situation where I had one spouse leave it to her husband for his life and then on to her children.
So the important takeaway from our discussion today is, one, in Texas, if you are married, property is presumed to be community. And if you want it to not be community, then you either need to keep it separated or more formally do some sort of agreement between you and your spouse on pre or post-marital agreement to show that it's been separated. Two, if you are the surviving spouse, you have a homestead right and a life estate in that property, regardless of whether it's separate or community. But you may end up owning it with somebody else that you didn't expect. And three, setting up a very detailed estate plan will alleviate most, but not all of these issues, because anybody with $300 and some odd dollars, if they're dissatisfied with the situation, file a lawsuit and try to challenge it. But essentially, setting up the most detailed estate plan that you can will remedy most of these issues, basically, right?
Yes, there's a couple of points I want to make, which are very interesting on how strong the legislature has made this probate homestead right for the surviving spouse. One of those is if the surviving spouse could own their own separate property, another house that their separate property, they still get the homestead right of occupancy in the house they were living in. So she could rent out her other house and still live in the house that they were living in while they were married. The other point is probate homestead is not only good for the widowhood of the surviving spouse, but as long as that spouse intends to occupy the homesteaded property. So even if the surviving spouse remarries, her homestead rights do not cease. So it's interesting. Yeah, she and her new spouse can live in the old spouse's house. So
I don't know if you'd want to do that. So I think it's pretty strong. Basically, understanding the community property laws in Texas is fairly murky, nuanced, even for those of us who do it on a regular basis. But with either by listening to this podcast or seeking counsel, you can sort of navigate your way through it. We're always happy to be a resource in that. Correct?
Right.
Well, thank everybody for listening today. Thanks, Stacy, for being on. And don't forget that before you go, there are things that you should know about community property and your homestead protections within the state of Texas. Thank you very much. Have a wonderful day.
Thank you.
Now, before you go, learn more about how Stacy and Keith can help protect you by calling or visiting us on the web. Links to our website and phone number are in the show notes. The information on this podcast is for general information purposes only. Nothing on this podcast should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt, viewing, or listening does not constitute an attorney-client relationship.